Good afternoon and welcome to everyone. I'm delighted to be here to present this webinar with my colleagues, Liam Reardon, David Ruddy, Fiona Shield and Lorcan Mall, and also our colleagues in Educate Together, Jennifer Butner and Emer Nolan. We're going to go through some of the questions that you have sent in. Hopefully you'll find it of some assistance. The chat box is disabled, but we are going to record this webinar, so it will be available to you afterwards. And there will be some questions and answers at the end, which we will deal with. So if I can just hand over to Emer now, who would like to welcome you too.
Hi everyone, I'll be brief. Just really first of all to say thank you very much to Mason Hayes and Curran for proposing this joint webinar. For those who don't know, Educate Together is a school patron, a charity, a membership organisation and a management body as well at primary level. And in that we aim to provide support to our schools. Jennifer Butner is here with me today. She's one of our member support team. So we're a growing school network. We now have about 35,000 students attending 117 Educate Together primary and second level schools around the country. And Educate Together schools face all the same legal and management challenges as all schools. There are some particular characteristics of our network that are reflected in the queries that come into our office. Firstly, because we've opened 50 new schools in the past 10 years, many of our schools are new or developing, and that brings particular challenges in terms of building a staff team and building a school community, lots of recruitment, for example. The second feature is that a lot of Educate Together schools attract particularly high numbers of families of students with additional needs, partly because of the explicit, I suppose, commitment to inclusion stated in our ethos, and partly because we have a large proportion of new buildings that have facilities for children with additional needs. But again, you'll see in the questions we're looking at today, you'll see that reflected as well in the types of queries that we deal with in our national office, that our support team deals with. And finally, I suppose a lot of our schools are oversubscribed, so we also have quite a lot of queries on admissions. So the same queries as all schools, and we very much believe in sharing information and sharing knowledge, and I suppose, you know, trying to prevent as much as possible challenges that all of us face in school management escalating. And a lot of that is about getting the right information in the first place, you know, making sure you're on a strong footing before entering into any kind of a management challenge. So we're particularly delighted, as I say, that Mason Hayes and Curran have proposed today's webinar. Very grateful to all our schools that have sent in questions that we'll be discussing. And other than that, I'm not going to say any more except to hand over to the experts, and I hope you all enjoy the webinar and take away lots of useful information and advice.
Thank you very much, Emer, and good afternoon. And just a big thank you again for submitting your questions and indeed for participating in the poll. And we'll have the results of the poll at the end of the webinar. So we're going to start off with the first batch of questions. And Catherine will be joined by Lorcan in relation to this. So school admission, Catherine, you're no stranger to this, and you're no stranger to the Workplace Relations Commission and indeed the Circuit Court when you represent schools. So you have a few answers for us and stories to tell. So over to you, Catherine and Lorcan.
Yeah, some of them I couldn't tell here now, but we'll start off with the question. The first question is the school's obligations regarding the processing of applications for enrolment from separated parents. Under the provisions of the Equal Status Act, the schools are obliged to treat everybody equally. Okay, so that includes separated parents. So I would say that you just have to treat them in accordance with your admissions policy and make sure that there's no discrimination there. In relation to a parent objecting, we have had a number of cases in relation to this. In particular, separated fathers have not consented to a child being enrolled in the school. And we've had a number of decisions from the Circuit Court which stated that the school should really keep out of any kind of family law matters, and they should enroll the child, because if they don't enroll the child, they have a Section 29. And maybe Lorcan can talk about the more recent one we have.
Yeah, so we had a really interesting case in the Circuit Court this time last year, and what really stood out to us in the judgment of the Circuit Court was that the judge clearly stated that really the matter in relation to enrollment of a child in a school and where there is a conflict between two parents as to what school they should enroll the child in, that's clearly a matter for the parents to resolve themselves. And if they can't resolve it themselves, they should go to the family law courts. And the judge quite clearly stated that it isn't the job of the school to resolve the conflict between the two parents as to what school the child should attend. The school is obligated to process and enroll a child in line with their admissions policy. And what we normally find is where a child or where a dispute arises is where a separated father might claim that he never got to sign the application form, and therefore it amounts to discrimination. However, what we have found in practice is that really it's only ever one parent who signs these enrollment forms, and this came out in the Circuit Court decision or evidence of the principal. He stated that it was very much the case that he only really accepts enrollment forms from where one parent has signed the form. And then we had a WRC as well, where the principal gave evidence that she said that 80% of the forms that she received only had one signature of one parent. And it really isn't the place for a school to interrogate or investigate why there might only be one signature, because each family is different. It could be a separated family, it could be a single parent, or it could be a widowed parent. And therefore, it's not really appropriate to look behind why there's only one signature.
And I think it's important to say as well that the courts and the WRC, they very much focus on the child involved, and any kind of dispute that there is between the parents, that should be left out of the school, and they should try and sort that out themselves. The school will just deal with the child.
So I hope that Catherine and Lorcan have given you some reassurance there in relation to the admission issue, which a lot of you are involved at presently. And the Workplace Relations Commission took over from the Equality Tribunal in relation to handling discrimination cases, just to be aware of that. Continuing with the theme of family law and disputes and that, I'm going to call in Fiona Shield, also from our education team. And Fiona is going to talk, she's going to address a few questions we have here. So Fiona, would you like us to take us through a few of the questions here?
Yeah, thanks, David, and good afternoon, everyone. So the first question that's appearing on the slide there is there a protocol that the school should follow in the case of parent-teacher meetings where a parent or guardian wishes to be accompanied by a new partner, or where a parent or guardian who is unable to attend sends their new partner? This crops up a bit. There's no issue with a parent bringing their new partner if they wish to do so. What we would say is that, the school deal directly with the parent as opposed to the partner at the meeting or indeed in any correspondence, but there's no issue if a parent wants to bring the new partner. The next question, can the new partner collect the child from the school? Again, we've no issue with this unless there is a court order to state otherwise. This is not an issue. And if parents are separated and they're having a row as to who is collecting the child, they need to sort that out amongst themselves. And as Catherine just said, disputes between parents should be left to the parents, and the school should try and stay out of it as much as they can in the absence of a court order. The next question, can the parent guardian object? Yes, of course they can, but I think my answers just there are relevant to that. And finally, is a school obliged to take into account the feelings of a student who says that they do not want one or another parent to receive school reports? Age is a relevant factor here. I mean, if it's a child who, like a primary school student who's quite young and says that they don't want their parent receiving certain reports, well, I think that should probably be disregarded, because the parents are entitled to see how the child is obviously getting on in school. But in relation to second level, we've had a couple of cases which have cropped up over the last few years where a 15 or 16-year-old student doesn't want a mother or a father to get their exam results, and we have advised the school that in circumstances where they are of the age and their consent is required, that their views should be taken on board. So age is a relevant factor to that particular last question. Yeah.
And Fiona, I think the Data Protection Commissioner did a consultation with schools, and in fact, the education team in Mason Hayes and Curran put in a submission, and age and consent, particularly at post-primary, as you say, is very relevant. Thank you very much for the clarity in relation to your answers there, and we'll come back to you in a few moments. Next, we're going to move on. The issue of transgender has come up in our questions there, and I'm going to call in Liam to deal with the legal aspect of it, and also to Jennifer to talk about the supports that and the resources that are available through Educate Together. Very interesting resources there. So over to Liam and Jennifer, please.
Thank you, David, and good afternoon, everybody. The first thing I want to say in relation to this topic is that it's an issue on which we receive very few queries from our clients, which indicates to us that schools are dealing with this, sensitive and complex issue relatively satisfactorily. And lots of schools have had issues on this. It's quite common. And but the feedback we're getting suggests to us that it's being dealt with very well in schools up and down the country. So just looking at the issue that's been highlighted here, Eamon's doing his leaving cert. He's just informed the school that he's transitioned to a girl, and he wants to play on the camogie team and wishes to use the girls' toilets. Just to start with the toilets issue, this can be a big issue in older schools. I think for most Educate Together secondary schools, most ET secondary schools are new build, up-to-date schools which have communal toilets for the most part. So it's not going to be an issue for Educate Together secondary schools. The question in relation to participating in camogie, in a girls' sport, the advice I would give to the school in this instance would be to check with the regulatory body controlling camogie and ask them what their view is. This is a huge issue in sport generally, and it's bigger than the school, if you like. And so the thing is for the school to keep itself aligned with what the sport is advising generally in relation to the participation of girls who may have male chromosomes still at their system in all male sports. The Gender Recognition Act at 2015 is the governing legislation on this, and it provides that a person over 18 can apply for what's called a gender recognition certificate, which enables them to transfer legally to their preferred gender. It's possible to apply for a gender recognition certificate if you're over 16 and under 18 with the consent of your parents and with medical support. And so while an adult can apply autonomously, if you like, a student between, say, 16 and 18 requires the consent of their parents. Jennifer, could I bring you in at this stage and just ask you to talk about your experience on this and what issues have arisen for you guys?
Yeah, thanks, Liam. Yeah, so I suppose any queries that would come to us, we would refer our Educate Together schools to the Ethos Guidance Platform, which has a section on gender variance, and that would include recommendations for schools, practice from some of our schools, and some resource materials to support. And in addition to that, following a motion from Educate Together schools at our AGM last year, Educate Together has established a working group in relation to LGBTQ+ identities with representatives of member schools on that to research and provide guidance to schools regarding good practice related to including and actively supporting LGBTQ plus children and their families in schools. And that group is currently working. It's ongoing. I suppose I have a question back there, Liam. How would a school deal with the situation where maybe a child or student discloses to the teacher or the school but doesn't want the parents to know? You know, how would the school deal with that?
Yeah. This is, I should say at the start that this is an issue which hasn't really become an issue for us. We haven't been asked to advise on this in any particular case that I'm aware of. You can see how it could become a significant issue in relation to a student who was over 16 and under 18, and who was advising a school that that they wanted to progress, or they wanted to transition to their preferred gender. I think the starting point for me would be to advise the school to deal with the student on a pastoral basis. In other words, explore what the student in question is looking for you to do. What is the student saying to you? Do they wish to commence a transition process? Do they wish to keep that from their parents? We advise schools in dealing with this to focus primarily on the student, to try to keep them aligned with their parents, and to try to bring everybody along on the same page at the same speed. Now that may not be possible, and there is a kind of an interregnum between, say, the ages of 16 and 18, where a student has a degree of autonomy, irrespective of the views of their parents. Now there's a limit as to how far this can go. I mean, for example, I mentioned earlier that a student under 18 can only apply for a gender recognition certificate with the consent of their parents. So there is a limit to how far you can go in recognizing student autonomy on this. But if you had a situation where the parents were adamant that, for example, a student couldn't be addressed by their preferred pronoun, for example, I think I would be inclined to advise going with what the student wanted rather than what the parent wanted. But it hasn't really been a huge issue for us in practice. It's more of a theoretical problem than a real problem, but you can see how it could become a real problem. And I think where it does, you have to look at it on a case-by-case basis. Try to see, can you bring everyone forward on the same page? If that isn't possible, you may have to make a decision to prioritize the wishes of the student.
So thank you very much, Jennifer and Liam, for that interesting insight there. And the takeaway I get from Jennifer is ethos is important, and Educate Together has some excellent documents dealing with the transgender issues and accommodation. And the takeaway I get from Liam is the pastoral approach to it, and that. So schools appear to be doing really well in relation to handling these issues. We're moving on to a totally different area, and this is the Protective Disclosures Act of 2022. Now, not many people may be familiar with this, but I'm going to give Liam mission impossible now, because I'm going to ask him literally in a couple of minutes just to give us a summary of this and to give us the heads up on it, because it's something for 2023 we'll need to keep an eye out for. Over to you, Liam.
Thanks, David. Okay, well, there's a new act in place. It came into effect from the 1st of December. The 1st of January 2023, and it updates the provisions of the Protected Disclosures legislation. The original act came in 2014. Most schools will have procedures in place based on the 2014 Act. There are a couple of new developments in the new Act. What is a disclosure is largely the same in that it's where somebody believes that an offence has been or is likely to be committed, that a person has failed, is failing, or is likely to fail with a legal obligation other than one relating to a contract of employment, or where the health or safety of an individual is being or is likely to be endangered. who is protected? There's quite a big change here because the 2022 Act widens the cohort of persons who are protected under the legislation. And that now includes not only employees who you would expect to be included, but people engaging in work experience, people acting as volunteers, individuals who are members of the administrative management or supervisory body, which would obviously include members of the board of management of the school. It also includes people who may have applied for jobs in the school, but who were unsuccessful in getting in being appointed. So they are also included as protected persons under the 2022 Act. The concept of penalisation is widened out to include not just the types of penalisation that you would expect, such as demotion and reductions in salary or whatever, but it includes things such as being excluded from training, and any harm that's inflicted on you by your employer by way of, for example, damage to your reputation by way of a bad reference, blacklisting of a person, early termination of employment or cancellation of a contract, and interestingly enough, psychiatric or medical referrals, which could be problematic in the education sector. So there is a need to bring policies and procedures up to date. I know that some of the management bodies are working on this already, and so there will be developments on this. But it's important just to ensure that your policy is up to date and that you are compliant with the 2022 Act.
Liam, thank you very much for that. A difficult task, which you've done so well. And hopefully that guidance that you referred to will be issued in the near future. We're now going to move on to a totally different area, that of student conduct and codes of behaviour. And I'm going to call back Catherine and Lorcan again to deal with this, because you have been involved in many Section 29 appeals and indeed in cases that have ended up in the High Court. So the first question there is a parent not wishing to engage with the school around behaviour issues. So
the first thing I would say in relation to that is that you should keep a good note of any kind of non-engagement with the parents. The school will usually try and engage and try and work with the parents to try and, deal with any kind of issues around behaviour. But if the parents don't want to work with the school, that's something that we need to take a record of. I mean, we have had Section 29s where parents have said they didn't receive any emails, they didn't know there was any issue with the child's conduct, and we could show that the school had met with these parents, had emailed these parents, and there had been just no engagement with them and no attempt made to try and resolve the issues and to work together. So that's very, very important.
And unfortunately, when the relationship breaks down, then the code of behaviour really is invoked at the higher level. So you've been involved in multiple Section 29 hearings, Catherine, and so the question here that has come in from one of our participants: should legal advice be sought in relation to suspensions and expulsion?
Suspensions, no, because this is something that is very much, it's common enough in schools, and I wouldn't think that you would need a legal advisor for that. Yeah. In relation to expulsions, it is a very, very difficult process, and if a parent wants to bring a solicitor along, it can sometimes help that parent, give a little bit of guidance to that parent. So I would say, yes, you should allow them to have their their legal advisors there, and you should seek legal advice also from us through Alliance. Usually they would be the people that you would go to. So I would say yes, definitely for expulsions.
And it's very much procedural, isn't that what you look out for forensically?
Yeah, the newbie guidelines, which you need to, make sure that you comply with. So yes, definitely.
So moving on, the school has decided to suspend a pupil, and guess what? The next day they arrive in school. What do we do there?
Yes, thanks, David. So yeah, that's always a very difficult situation for a school if a parent rocks up with a child who's meant to be suspended and leaves them at the school gate. And if that does occur, the school does have a duty of care for that child as they are on the property of the school. So in that instance, we wouldn't usually suggest that they would do an in-school suspension, and they would sit at the back of another classroom, and they'd be given work to do. And then you would follow up probably in writing to the parents and convey that, that wasn't the appropriate thing for the parents to do in that instance. But you should be supervising that child. It's not appropriate to leave that child in a corridor or anything like that unsupervised. He needs to be supervised because that duty of care still exists.
And Lorcan, to follow on from that, we have a situation where there has been an incident at the school. The principal decides to suspend the student without affording the parents an opportunity to come along. Can a principal do that?
So that situation would normally present in a case where there's a serious health and safety issue, and there has been an incident in school, and really you need to get that student off site, not just for his or her own safety, but potentially other people's safety as well. So that can be dealt with. The parents can have a right to respond to the suspension, and they can do that later down the line. But it is important, the school does have the authority to impose an immediate suspension where there is that health and safety risk. And a lot of schools would have an appeal mechanism within their code of behaviour in relation to suspensions. And if that does exist, then you would afford that parent the right to avail of that appeal to the Board of Management. And if the board decide that the suspension wasn't warranted, then the suspension can be removed from that student's record. And that's the best way for the matter to be dealt with.
And then, Lorcan, what happens when a parent decides to bring or they inform you that they're going to bring a solicitor along to a meeting in relation to, one, a suspension, and secondly, an expulsion hearing? Again, what would you advise?
Well, Catherine and my advice would be that for a suspension, we wouldn't recommend, or we would be objecting to the presence of a solicitor at a suspension hearing. It's not that serious, unlike an expulsion hearing, where the presence of a solicitor might be welcomed, and it might be necessary for a solicitor to be present for the parents. But for a suspension, no, we would be objecting to the presence of a solicitor there. And Catherine, I don't know if you want to weigh in there as well.
No, I'd agree with that. I mean, a suspension it can be very minor, so there's no need for a solicitor to be there.
So that's straightforward and a very direct answer there. So we move on to expulsion now, and the principal basically recommends expulsion, or can they come to the board and say, well, this is what has happened, my investigation is complete, it's up to you now. You can pick suspension, expulsion, or whatever.
No, I mean, you have to be very clear as to what you're recommending. If you're recommending expulsion, it has to be recommended. And then maybe the board can, look at it and see if there are any other alternatives to expulsion. But it's very important that the parents know that you are recommending expulsion and that you're very clear with them about that, because otherwise you'll be criticised later.
So that they're not blindsided or
exactly.
And that. And this probably leads us then, to fair procedures, which is the last question there. So you might address that in relation to the hearings and the whole process.
Well, I mean, Lorcan and I have, recently advised on one, and maybe Lorcan can deal with that in a minute, in relation to providing all the documentation to the parents so that they have everything that the board will have, and providing them a right to come before the board. All of those things are very, very important.
Yeah, I would agree with that. And I think it's, fair procedures also provides for, that you're following the procedure set down in your code of behavior in line with the newbie guidelines. And we were advising a school before Christmas in relation to an expulsion, and they kind of missed a step, or they misunderstood a step. And that means the expulsion had to be redone. So, and that's something the Section 29 committee will look at closely as well, as to whether the procedures have been followed and there hasn't been a misstep. So that's a very important and essential element to fair procedures as well.
And I think the important thing as well is to say that the code of behavior also applies to children with additional needs. And you had one recently where we dealt with something like that, where the expulsion was actually upheld.
Yeah, so sorry, go on, David.
No, absolutely, yes. Yep. Laura,
yeah, so sorry, yeah, we were successful in a Section 29 there just last week in relation to a child who presented with additional educational needs. And, the Section 29 thankfully followed the footsteps of a High Court judgment or judicial review that Catherine was involved in relation to another child with additional educational needs. And it's good to see that the Section 29 committees are following that precedent and are in compliance with it as well.
And I would say, just in relation to that, to additional needs, and that the schools did demonstrate that they went over and above and beyond in relation to accommodating these children by giving them extra resources, by charting their behaviours, and by supporting them, seeking advice. Working to the expert reports, seeking support from the NCSE, TUSLA, etc. So, but you have to prove that you went over and above and beyond.
Yeah, you do. And I mean, there's a balance between the right of the education of that child and the rights to health and safety of the other children and the staff, so that has to be, that's a fine balance.
Thank you for that. And we work neatly then into the next piece, behaviour of concern. And we've had a few questions on that. So I suppose the backdrop to this is that schools are experiencing elevated levels of challenging behaviour. And a Mason Hayes and Kern poll last year of school principals found that 75% of them said that they had issues in their school relating to behaviours of concern, and 2/3 of them said that they weren't particularly confident in dealing with these challenging behaviours because there are no simple answers. If you look at some of the questions here that have come in, like the impact of the Admissions Act, for example, has meant that schools now have opened AS classes. A large cohort of schools have done so. Large schools and indeed very small schools have opened AS classes in order to accommodate children with additional needs. And secondly, the most recent and final piece of the Admissions Act that has been commenced has put an onus on schools and on boards to insert in their admission policy a section saying that they will cooperate with the NCSE and with TUSLA in relation to this accommodation. So in relation to behaviours of concern, just bear in mind what Lorcan and Catherine have talked about. I can safely say 100% of the cases have dealt with behaviour that constituted a health and safety issue. Typically it would be attacking a student, attacking staff, behaving in a way that put others in danger, running onto the road, or as they're known as runners. What do we do in situations like this, I suppose, is the big question. And unfortunately, there's no guidance from the department or a policy template in relation to the use of physical intervention. So like a question there, what are the options available if the setting and the placement is wrong? Well, the AS classes do have a teacher and 2 special needs assistants. Some classes actually have 3 special needs assistants. And we know that the more staff and resources we have, the better we can cope. But even with that, some schools are in inappropriate placement, and barring the transfer of the student to a special school, the school really have to exhaust all the procedures available, and ultimately their safeguard is the code of behaviour. And if that means sanctioning the student or indeed excluding them, ultimately it has to be done if it's the only way you can guarantee health and safety. Just in relation to physical intervention, there are 4 different types of physical intervention, moving from the lowest level, which is presence, to leading, guiding, ushering. And this is international best practice, to hold in a student, to prevent them hurting themselves, stopping them from running out on the road, as mentioned. And finally, then, in a crisis situation, we have restraint, where 2 adults have to restrain a particular student to stop them from seriously hurting another. And in relation to these interventions, I would say to you, I think it's really very important that we rehearse scenarios. Who is the person in the school best placed to deal with a situation like this? It may well be the special needs assistant as opposed to the principal, because of that relationship between the special needs assistant and indeed the student. It may be the class teacher or the resource teacher. And I think schools should really reflect and spend time dealing with scenarios. I mean, after all, you rehearse a fire drill, don't you? So why not rehearse a crisis situation like this? Ultimately, I think the touchstone for you in deciding in what our response is boils down to the concept of duty of care, and Laura can refer to this earlier on. We in schools act in loco parentis, we're in the parental substitute, and the standard of care required by us will be judged on issues like the age of the student, the context of the incident, and the cognitive capacity of the particular student and the circumstances. So the reasonably careful parent test is what the courts apply. What would a reasonably careful parent in a school situation do? And if the answer is, if by me restraining that particular child from running out onto the road, or intervening, separating 2 in a fight, or even having to restrain some individual, is what I did reasonable, proportionate, and necessary? The one thing we cannot do is look the other way and pretend these things don't happen. And this is why rehearsal is important. There's a question there in relation to training. And at the outset, I would say that the National Council for Special Education have resources and do offer supports and guidance to schools. And we have referenced the links below there. We in Mason Hayes and Kern also provide training, and this is on the basis of requests from schools. It's a 2-hour online or indeed blended training with a face-to-face aspect, where we go through the legal and compliance piece. We also look hugely at the recording, de-escalation strategies, and we also provide templates, recording templates, and indeed a policy template, which would be used as an appendix to your code of behaviour. We're now going to move on to the question of staff issues, and you have been polled in relation to that, and it'll be interesting to see what the results are there. So I'm going to call back Liam and Fiona in relation to that. So over to Liam and Fiona in relation to this.
Thanks, David. So the first question there, may a teacher refuse to allow the principal to enter the classroom? The short answer is no, a teacher can't refuse the principal to enter their classroom. At the end of the day, the principal is responsible for the day-to-day running of the school, and if he or she wants to attend a teacher's classroom, he or she is entitled to do so. We would say, though, just to exercise a degree of caution, obviously don't target one particular teacher that you keep frequently attending their classroom as opposed to another staff members, because that might give rise to a grievance. But there is no issue with the principal attending a classroom is the short answer.
And that's underpinned through the Education Act also, isn't it, where the principal shall direct teachers and shall manage the school. The next piece, Fiona, again, this is the teacher refusing to meet a parent, and maybe the following question of refusing to teach a student. So what would your advice there be?
Yeah, so may a teacher refuse to meet a parent? The short answer to that is, well, like, they can, but we don't think it's a good idea. Obviously, if the teacher, I don't know, if there's a health and safety concern or something around meeting a particular parent, that's a different story. But in general, no, it's not a good idea for a teacher to refuse to meet a parent. I don't know, Liam, do you want to row in there?
I agree with that. I mean, it would be crazy for a teacher to refuse to meet with a parent. It does happen occasionally, but it's very ill-advised. So I suppose the answer is, may a teacher refuse to meet a parent? They may, but should they refuse to meet a parent? Absolutely not. Is it a bad idea? Yes. You know, it's not going to solve anything, and you know, at most it's a short-term expedient, but it generally makes things worse.
And following on from that, thanks for that, Liam. Refusing to teach a student, I don't like the student and they're troublesome. Yes or no?
No.
That's unanimous. I'm going to move on to the next slide there. We've agreement there. We'll see how we agreement in the next few questions here. So we're on to the staff member who's refusing again. So over to you there.
Lots of refusal issues here. So yeah, what should a principal do when a staff member refuses to attend a disciplinary meeting? It's obviously not a good idea, and that kind of raises its own disciplinary issue in itself if a staff member is refusing to meet. It's a tricky situation, but it obviously makes things a lot worse. I guess the staff member should be advised to seek independent advice if they're choosing to go down that route. But yeah, it's certainly not a good idea, and it doesn't help matters.
Yeah, sometimes I've come across cases where I've heard there's a reluctance to come to a meeting, but the reluctance is often it's rationalized in the sense that you get a letter from the union or from the teachers, solicitors or whatever, setting out certain issues that they have in relation to the process before they come along, and that's a different thing to what, say, Fiona was talking about, where somebody just puts their head in the sand and refuses point blank to come to a meeting. And Fiona is absolutely right. That just makes things worse, because the teacher's compounding their wrongdoing in simply refusing to come along. But most of the time, it'll be wrapped up in a rationalization or a series of questions in relation to the process coming from the union.
Okay, so clarity being provided then, that's fair enough. So the next piece then, thanks for that. If a teacher subject of a stage 1 disciplinary proceeding, also raises a grievance. Yeah, so getting the retaliation in, you're going to discipline me, so I say you're a bully. Can I stall the proceedings?
In a word, no. The two procedures are completely separate. And the fact of the teacher initiating the grievance doesn't put a stop on the disciplinary procedures initiated by the principal. If the teacher feels that they've been unfairly treated by the principal in the context of the disciplinary process, they can appeal the matter to the Board of Management. So they do have some degree of they have redress. They have a remedy available to them if they're unhappy with the outcome of the disciplinary process. But the fact of a teacher invoking a grievance doesn't of itself create a conflict of interest, and it certainly doesn't stop the disciplinary process.
That's really great clarification there, because good management doesn't mean that one has been bullied. Absolutely not. No, thanks for that. And the final piece there, I know that Fiona and yourself are concerned at times about a board being quorate in relation to making decisions. And at times we lose sort of board members as we go along if they're involved in the investigation and that. So What do you have to say about that, Fiona? I think
Yeah, so
in
in those scenarios, yeah, I mean, the board can nominate external members. So we had a case recently where a staff member was being disciplined, and for various reasons, there were a number of board members that were conflicted, and as a result, the board nominated 2 external people to deal with the disciplinary matter. It worked quite well, and it meant that the procedure wasn't stalled. So the external people who we got had an education background, and they were well equipped to deal with the matter. So yeah, it's just something to bear in mind.
No, that's great, Fiona. Thanks for that. And Jennifer, do you ever get requests from your members from the boards in relation to this nominee of the board, looking for somebody independent, as suggested by Fiona there?
Yeah, we would often get those requests, and we would have a few people that we would recommend to boards. So yeah, that often comes to our office as well.
So I think that's certainly important to bear in mind. Thanks for that, and thanks to Liam and Fiona and Jennifer for your assistance with that. So the final piece here is the disciplinary procedures themselves. Now they go from 1 to 5. So can we skip stages?
Yes, you can. There's a certain contradiction in the procedures, because on the one hand they say that the procedures need to be followed sequentially, starting at stage 1, working through to stage 4, and the teacher unions tend to emphasize that particular aspect of the procedures. On the other hand, they also say that it's open to school management to initiate the process at whatever stage is appropriate to the gravity of the alleged misconduct or the alleged incompetence or whatever. So you can, as a principal, as a chairperson of the Board of Management, you can initiate the procedures at different stages. So that's
an important clarification there. Is a right to legal representation provided for in the disciplinary procedures? I suppose the legal representation, in relation to the teacher, the subject of it, or special needs assistant, or
so it's not explicitly provided for, but there's nothing in the procedures which say that you cannot have legal representation. We have attended disciplinary hearings with the Board of Management, and we have had cases where staff members have had legal representation attending, particularly in circumstances where a disciplinary hearing might result in someone's dismissal. It's obviously a very serious sanction. So I wouldn't be resisting a staff member's, if they want to have legal representation there, then I wouldn't be resisting it, because obviously, it's quite serious. So, I think Catherine said it earlier, it's not something to necessarily be scared of, and it can actually help the running of the meeting. So, yeah.
So Fiona, I take it we're really talking about stage 4 there, because you suggested that a person may be in danger of losing their job. And a question here somebody has: what are the most common issues that elevate to a stage 4, or indeed commence with a stage 4?
Yeah, it's hard to generalize, really, David. The most common issues are conduct issues.
As opposed to competency.
As opposed to competency issue.
Yeah. Okay. Right.
There's a range of serious misconducts identified specifically in the in the procedures, such as, we'll say, making inaccurate returns to the Department of Education, severe bullying, financial irregularities, and so on. All of those issues crop up, but most are conduct issues. There's a paucity of competency issues, because there were very few cases brought in relation to competence under that particular provision of the disciplinary procedures. So there's a dearth of those
Yes, Liam, I think the PDST at one stage said there was only about a dozen. So out of 70,000 teachers, does it mean that they're all, I'm sure 99% are very competent?
Oh, absolutely. Yeah.
I suspect that there are many more than a dozen who are falling below that threshold. Thanks very much to Liam and Fiona for answering those questions so succinctly. And we're going to move on to the final piece here, which is social media. So I'll pass over to you, Catherine, in relation to that, and possibly Lorcan, if you'd like to come in. Catherine.
Yeah, I mean, the first question there is the school potentially liable for social media postings? It obviously it depends. Every school would have social media policies in place now, so people should know, teachers and students should know that they can't put anything up on social media that will, affect the reputation of the school, or also affect the health of the students or the staff. So you would have to, in relation to parents, what we usually do is the chairperson will send quite a stern letter to the parents, informing them that they have a duty of care towards the staff and asking them to remove the posts, and that usually works. In relation to staff, you would have to deal with it under the disciplinary procedures, and go all the way up from the informal part right up to stage 4 if they don't stop their behaviour. And in relation to students, it's a code of conduct issue. And we did have a case one time, well, we've had a few where students have put up false Facebook profiles, false Instagram profiles in relation to staff, and have been suspended and indeed expelled on a few occasions in relation to that. So that's how you would deal with that. We would have to have a very clear social media policy in place that links to the code of conduct and to the disciplinary procedures, so that it's very clear that that's how it's going to be dealt with.
And we need to be proactive, of course. We just kind of say because it's on social media, we have a responsibility.
Absolutely,
and again,
yes.
You go back to the policy there. And the Teaching Council, of course, have a code of conduct in relation to social media also. And the final piece there, in relation to cyberbullying of students or staff, that's a difficult one, isn't it? But
it is, and I suppose the risk is that the school would say that it has nothing to do with them, and that's kind of a dangerous stance to take on it, because if it has an effect on the student, then the school needs to step in, and we have had cases where the school has investigated it and used their code of conduct against the boys that were involved in that case, and they were suspended. So, we could show that the school had taken steps and used its social media policy code of conduct, and that was very helpful for us in the defence of that case.
Catherine, thanks very much for that. And I think that brings us to our poll results. So I'm looking forward to seeing what the poll results are. So Carolina is going to put them up here, and I'm going to ask Jennifer or Emer or indeed Catherine or any member of the team to comment on them if you have a comment. So the first one there, in relation to the biggest challenge for you as a school leader, managing staff 50% and students in at 33%. Is that surprising to anybody, or would that be along with? Would that accord with the level of queries we get into the education team, Catherine?
It would. I mean, the majority of our queries would be in relation to staff and how to manage that, yeah.
So the next piece down is what members of staff do we have the issue with? So caretakers and secretaries at 36%. The cleaners, 37%. So it's very close there, and 2/3 not having an issue with either, which is a very good sign. And finally, special needs assistants, 39%, a bit higher. I suppose we have more special needs assistants than we have caretakers or secretaries or cleaners. And the last one is the teaching staff. Wow, 51%. Have issues in managing, and I suppose that's of course down to the numbers on that too. And again, that might replicate what we come across in the education office. Would it, Catherine? Nothing surprises you there?
No, it's all
as
expected.
And Emer and Jennifer, you're remaining very quiet there. Any reaction there?
Just
They
to
would-
observe that I suppose the greatest number of staff that anyone is managing would be teachers. So it's
Yes, so, okay, that might explain that.
Yeah.
Lies, damn lies, and statistics, isn't it?
Yeah. But
And
also
just to
what's
say,
very striking is that last one there on cyberbullying, that only 10% don't find an issue with cyberbullying. I suppose that's very striking, isn't it? You know, another, I suppose, new challenge. There just seem to be more and more new challenges all the time, and the old ones don't go away, unfortunately. So that's very striking. Yeah.
no, thanks for that. And thanks to everybody who participated in the actual poll itself. Thank you, and for submitting the questions. I'll now hand over to Catherine and Emer just to do the wrap up. Thanks.
Well, I think just before I do that, there are a number of questions that I might throw out to the team as well. There's one in here about the Protected Disclosure Act, the issue of giving reference, and, you know, do we have a legal obligation to give a reference? And there is none. And I think a lot of people don't know that there's no legal obligation to give a reference, like a character reference, what people used to get. They're only entitled to a statement of employment, which basically sets out their period of employment and their role in the school. So that's important to know. Also, there's a question in here about the shortened day and whether or not you can oppose that without the consent of the parents. And our advice on that is that you couldn't do that without the agreement of the parents.
And the circular that came in there recently
changed that. It used to be the case that you could, but that has changed now, and you have to have the agreement of the parent. There's also one here: can a board of management prevent a deputy principal from becoming acting principal in the event that a principal is absent? I'm not sure that you would be able to do that, to be honest with you. We probably need more information on that, but that would be something that I'm not sure you'd be allowed to do.
I agree with you, Catherine, on that, because the deputy principal is perceived to stand in the shoes of the principal when the principal is absent, and all things being equal, it's reasonable to expect that the deputy principal would stand in for the principal, particularly if the deputy principal wants to do that. So I think we'd want to hear more about that. But I agree completely with you, Catherine.
Well, I mean, if there's an underlying issue as to why they have concerns about that, that should maybe be dealt with.
That should be, I think we should have a chat about that.
Yeah. Okay, thanks. So if we want to hand over to Emer now to say a final word. Thank you.
Yeah, so just briefly again, many thanks to David and all the team there in Mason Hayes and Curran, and thanks to everyone who sent in questions, and to Jennifer and Keith and Alison and our member support team for putting the questions together and planning the event. I suppose what we're always trying to do is to provide better information and support to the principals and boards of management that manage our schools, and this webinar is part of that. You know, what we want is for the boards to have the knowledge, the resources and the support they need to carry out their management functions kind of effectively and efficiently. But we do know that this can be challenging, especially as the demands of school management have become more complex. It did strike me while listening to the various, you know, pieces of advice and information, that the legal information and advice is never enough. You know, the types of situations that we've been discussing here are often very, very difficult. You know, there are practical challenges, difficult ethical decisions to be made, and that can be extremely stressful for principals and for boards. And sometimes the legal advice, when we listen to it on its own, it can sound very technical or impersonal. And so just to say that we do know that these situations are always intensely personal and difficult. But the legal advice really is the essential foundation. You know, we all know that it's possible to make a bad situation worse if procedures aren't followed or if the right policies aren't there in the first place. So the first step is to be clear maybe on the legal context and what the regulations are. And then what Jennifer and the support team will try to provide along with that is a sounding board as you try to work through the best course of action for you in your school. And sometimes Jennifer and the team will be able to share examples of what other schools have done, or examples of what not to do from experience, or sometimes they'll be able to put you in touch with another school that's been through something similar, which can be really valuable. And we're always very lucky that our principals and boards are very generous in supporting each other. And we also obviously try to do anything we can as well. So, you know, just to say again, really, really helpful, really valuable advice there. Thanks very much to David and the team, and thank you all for your questions and for coming along.
Thank you.
Thank you.
Thank you, Mira.
Thanks. Bye.